Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera to my Industrial Relations, Regulations and Cybersecurity lecturer, Dr. Muhammad Shanawi bin Muhammad Pirus. Let me introduce myself first. My name is Nur Karimah binti Azmi with matrix number 2020-52-1671. Today, I would like to present my individual assignment of the case of law on industrial relations. In this case, it involves between two parties, which is the claimant Cui Kian and Kitakon Sendirian Berhad. Okay, first, let's take a look at the facts of this case. As an overview, on 5th November 2009, the claimant was taken into employment as a project manager cum site manager. During his service, he received negative feedbacks from his colleagues being repositioned and numerous complaints were received, which resulted in 7 warning letters being issued against him. And finally, on October 2016, both parties agreed that the claimant's employment be terminated, which the claimant willingly acknowledged. Moving on, the next slide is the issue for this case. In this case, I found some questions and problems that arise from the claimant's side and his ex-company, which is the first issue, whether there was a mutual termination of employment between the employer and the employee. From my study and research, yes, the claimant was terminated and was issued with a letter of termination, which the claimant willingly acknowledged. The next issue in this case is, on what basis does the claimant file a claim of unfair dismissal? So in this case, the claimant claimed that he had been discriminated against as other employees had also been late, but no disciplinary action has been taken against them. Okay, the next issue is whether the dismissal was with just cause and excuse. Okay, from my understanding, the company's final act of terminating the claimant's employment was with just cause and excuse. Another issue is whether the court can adjudicate a purely monetary claim for the claimants. As the employee did not want reinstatement, which is actually the primary relief in unfair dismissal claims, the industrial court held that it had no jurisdiction over the matter and struck off the case. So here is the judgment for this case. Okay, the judge decided that the claim was dismissed by the industrial court because the employee eventually confirmed that he did not want reinstatement and was actually looking for monetary compensation from the court. Okay, as the employee did not want reinstatement, which is actually the primary relief in unfair dismissal claims, the industrial courts held that it had no jurisdiction over the matter and struck off the case. Okay, here are my analysis for this case and my personal critiques specifically on the issues that I've explained earlier. Okay, as we know, a long dismissal, the termination by mutual agreement, which is the rupture conventional, makes it possible for the employer and the employee to agree on the terms and conditions under which the employment contract may be terminated. Okay, the signature of a termination by mutual agreement, each step aiming to ensure that the employer freely gives their consent to the termination of their employment. So in this case, the claimant's ex-company has provided precisions on the requirements to validly conclude that a termination is happened by mutual agreement. So considering the above, I can say that it is proven that they both have come to a mutual agreement before proceeding to the official dismissal due to the causes and reason which they both aware about it. So it is impossible that the claimant could not have freely agreed to the termination since he was aware that the time he signed the agreement, there was a mutual termination of employment between both parties and the claimant was actually aware about his mistakes. So, to claim and file for unfair dismissal on his ex-company is actually illogical When he claimed that he had been discriminated against other employees, the company refuted this with the claimant's ex-colleagues, and they testified with valid reasons and also explanations. So for your information, 5 months before he was terminated, the claimant, which is Chu Yik Ken, he was absent for 2 months, giving his hospitalization as a reason, but he could not furnish any documentary evidence like medical certificates, MC, or even a letter from the hospital. So responding to this, to his ex-colleague's testification, the claimant agreed that in the month in which his employment was terminated, he had not been late to work for even 1 day. But he must not make this as his excuse of unfair dismissal, thinking of the numerous lack of working ethics he has made before. So this does not impress the court because it ignores the numerous other times he was actually late for work and even absent for work for months. So next, let us see if the company made the decisions of terminating the claimant was with just cause and excuse or without consulting the claimant. So the company's final act of terminating the claimant's employment was with just cause and excuse. That employee must have proper justification and reasons to terminate the employee. Okay, although the company's general manager, which is the COW1, had received negative feedback regarding the claimant's performance and also his work attitude from the claimant's colleague, the company still tried to arrange a more suitable position for him, suiting his capability, but however, the company continued to receive criticism regarding his performance and also attitude. In addition, the claimants keep on causing serious problems to the company, which the company just only reassigned to a lower position with his benefits unchanged except for the omission of his transport allowance. Thereafter, the claimant was excessively late for work, absent for 2 months, and after presenting himself, he even requested for a change of working hours, giving that the reason he needed to send his child to a daycare center and was kindly approved by the company. However, the claimant continued on coming late, and finally, the company engaged in discussions of termination with the claimant, who insisted that he could not adhere to the original working hours, and both parties acknowledged that decision. So, in this case, I would say that the employer is actually kind enough to overstretch its patience to accommodate the personal issue of one lone employee. So in this case, even the judge himself stated that the claimant as a difficult employee. So as an endnote, the court must mention the recalcitrance demonstrated by the claimant whilst under cross-examination by his refusal to face up to the facts confronting him. He was actually disputatious and at times to the point of taking on himself the role of the counsel, so much so that the court had to remind him several times of his place and role in the witness box. Hence, I would like to conclude that in this case, it is actually fair for both parties, considering the causes and excuses made by the claimant. So, as you can see here, these are the references for the assignment. So with that, I would like to say thank you, everyone, for your time and for listening to my presentation. I hope that you guys are having a great day today. So with that, thank you. Assalamualaikum warahmatullahi wabarakatuh.